forward. You've got 8 minutes.
Gur míle mágad Cathaoirleach Gníomhaigh agus chuir fáilte róta ara agus ribh an bille freisin atá anna hábhachtach ar fad agus buachlam mo chuid buchas agus buchas an grúpa Fine Gael go bháil le Bridget McManus agus an tuairiscí dhéann si ar an ábhar seo agus an ábhar tá déanta ag a grúpa freisin. It's a very important bill, Minister, and I think it's something that may have a niche area, but actually it's going to have much wider repercussions than just much of the legislation that goes through this House that will be of this kind of technical element and this size. But in your speech, you mentioned a number of things that I think are really important in terms of the functioning of our criminal justice system and the access to justice for people. And one of the things that I have said in this chamber on a number of occasions is that we actually have a very functional, a very fair, a very reasonable criminal justice system that works for the people, both the victims and the defendants that are before the courts, and for the people who need that system to function. However, one of the areas where we are definitely falling down is in terms of the time it takes to deliver decisions, decisions in relation to all kinds of legal matters, be they disputes between individuals and the state or companies, or of course criminal prosecutions as well. And at the moment, for example, if you go into the Circuit Court today and ask for a trial date, you will be looking at a date in the second half of 2025. That is grossly unfair. The same is true of the Central Criminal Court. It is grossly unfair on the people involved in those cases, be they victims or defendants or witnesses or whatever it might be. And that is something that we must address as a matter of urgency, and I believe this bill will go a very long way towards doing that. I welcome the fact that the Minister has previously indicated as well that it is not just about appointing judges, it is about appointing the resources that those judges need to function. That means courtrooms, spaces where cases can be heard, and the civil service, court service staff who are there to make sure that the courts can run properly, because one without the other doesn't work and isn't going to improve the situation. So I very much welcome the fact that we are addressing this problem. And the number of judges you've mentioned in terms of the Court of Appeal, the High Court, the Circuit Court and the District Court, I think will go a very long way towards helping us to address the very unfair and very problematic delays that there are in terms of getting cases dealt with in the courts. So the report from Bridget McManus and her group has been tremendously important in establishing the need for these changes, but it's something that we all see, and anybody who's dealing with any individual around the country will have heard complaints about the delays that there have been in bringing cases to trial and bringing cases through. In your speech, Minister, as well, you mentioned the importance of the functionality of the courts and therefore the access to justice, which obviously is a fundamental right constitutionally in terms of the European Convention, etc. But access to justice comes in a number of different ways, not least of which is representation before the courts. And I foresee a repercussion from this bill and this act that is something the Department has got to be aware of, and that is that a lot of these positions will be filled from the bar and from the role of solicitors, people who are currently practising in our courts and providing legal services. And as they leave, they will have to be replaced. But at the moment, as you know, Minister, there is a real problem, particularly in the sphere of criminal legal aid, in terms of the number of people who are entering into the criminal bar and criminal practice as a solicitor, because of all of the groups who had their fees cut at the time of the financial emergency in this country, legal aid practitioners, solicitors, barristers have not had them unwound, and they are the only group. For some reason, the Department of Justice or the government has decided that it is somehow acceptable to single out this one group and decide that their fees should not be restored. So the cuts that they've endured of between 30 and 35%, depending on where you measure it, have never been unwound. And the reality is that although there may not be actual evidence of it, because it's very difficult to enumerate, for example, whether somebody has decided to leave the practice of criminal law in favour of another area law or in favour of another industry altogether because of those fees or not, that's very difficult to establish. But anecdotally, we know there are far fewer people going into the practice of law at the beginning, at the qualification stage, and there are more and more senior people in criminal law particularly, who are choosing to go into a different industry, to leave the bar or to leave the practice as a solicitor and go in-house or go into a different area of law. That is real. And As you take more and more practitioners out of the criminal sphere, that is going to exacerbate that problem. But one of the key things that we can do as a government to address that is to actually have a responsible approach to the levels of payments available for those practising in criminal legal aid. And the thing that people don't understand when they're talking about this is we're not just talking about defence practitioners. And in this House, all the time we talk about the importance of dealing with offences, serious offences against individuals, but the pay for prosecution counsel or solicitors and defence counsel or solicitors is the same. There's a statutory instrument that ties the two together and they can't be different. So when you cut the defence fees, you cut the prosecution fees as well. And you're discouraging people from being available to prosecute important matters and to make sure that perpetrators of criminal activity are brought to bear and brought to justice. So the time has come now, Minister, particularly in light of the reforms that are in this bill, to change the government's attitude to the paltry approach to the payment of important professionals who, by the way, save the state a small fortune in terms of what they actually provide for the state. You don't have to pay employers' PRSI, holiday pay, sick pay, parental, maternity, paternity leave. None of that has to be covered by the state. You have a coterie of independent practitioners who pay all of their own bills. They're all self-employed. They all look after themselves. And they save the state a small... We pay less per head of capita for legal aid in this jurisdiction than in any other common law jurisdiction in the world that I'm aware of. So the state gets excellent value for money for legal aid, notwithstanding the efforts of some in the media to paint huge figures, which of course include VAT as well. The reality is that we know the importance of paying people properly for the job that they do, and when we stop paying them properly, then that job isn't done, or isn't done properly. And the reality is, particularly, this is an area, because one of the features of the bar, in my opinion, is that lots of people come to the bar as more mature people from a second career, maybe older. But if you're coming to the bar in your 30s with children and a mortgage, you can't practice criminal law because you can't afford to. So the reality is that the only people going into criminal law are those who are straight out of college. And that's a real shame. And it's a real missed opportunity. And I really hope, Minister, you'll bring back the message to your department and to the other ministers in the department that this has to end and we need to take serious, concrete steps about restoring legal aid fees. It's not something I haven't said before. It's something I have said before on a number of occasions, and I know you're aware of the arguments. Can I finally say then, in respect to this bill, that the other thing that I think the opportunity we've missed, because about 25, 30 years ago, we changed the retirement ages of judges, particularly in the superior courts, reducing it from 72 to 70, which means that there are judges, well, as soon as they hit 70, they have to retire. And I really think that is something that is totally unnecessary. I would like to see us undo that. I know that there are concerns, but the reality is that most people are functioning later in life now, and they're able to work later and want to work later. And if you have an experienced judge who is willing to work later than 70, then he or she should be able to do that. I'm not saying we shouldn't put in place controls or safeguards to ensure that that person is still able to do the job, and maybe there could be an annual approval by the president of that court or by an outside body or whatever it is. But we have in our judiciary a coterie of people who are really effective, really fair, who follow the rule of law and who do an excellent job for this country. Cutting them down at 65 or 70, depending which court it is, I think is just an unnecessary waste of that human capital that we have. And again, it addresses the issue that we know we have in terms of the requirement for the availability of judges to deliver the accessibility to justice that you referred to in your own speech. But I welcome the bill on behalf of the Fine Gael Group. I think this is a forward step, and I look forward to the appointment of those judges to smooth through those cases that are being delayed in our system as it stands.
Thank you very much, Senator.